what I'm going to do because I'm recording. Okay. All right, guys. Yay. So I am here to talk about legal stuff that every realtor and property owner should know. Subtitled, Property Ownership, the American Dream or the Texas Nightmare.
Dun, dun, dun.
Dun, dun, dun. Yeah. All right, so let's discuss how some concepts that can affect your property ownership. Oops, go back away. And one is, how do I get rid of this? Can I move that? Yep, I can't move that.
Made it worse.
I just made it worse. Loving this.
Looks fine from over here.
Okay, oh, there you go. That's better. That's way better. Okay, all right. So let's discuss some information that could inform or restrict your ability to buy or sell that land. The first concept that we need to discuss is community property versus separate property. In layman's terms, it is what's mine is yours, even if it's not. In Texas, under the Texas Constitution, which is the highest law of the land of Texas, there is a presumption that if you are married, if you have signed a marriage license, that everything you own is community property, meaning it belongs half to you and half to your spouse, regardless of who paid for it. That is the presumption. That presumption can be overcome, but it has to be overcome, meaning if you want to claim that some property that you are trying to sell is yours and yours alone, and you should be entitled to all of the proceeds of it, you have to do something called, and how to move the next slide. Oh, perfect. Okay. All right. So let's talk about a story. We're going to have 3 stories in this presentation. The first is the story of Bob. Clearly, these names have been changed, but Bob is actually Dustin Vossik's friend. All right, Bob has an offer on a rental house he inherited from his grandma for a good price. The market is hot and the profit looks great. Bob is really motivated to sell. Guess what? Closing is scheduled in 3 days. He cannot wait. This is great. But oh, the title company says, no, Bob's wife has to be at closing. She has to sign off on this, on the closing documents and on the deed to the buyer. But wait, Bob's wife is gone. She left 6 months ago to move to California with her hairstylist. So what are Bob's options? Anybody have any ideas of what Bob can do?
Legal?
Yeah, or any, well, yeah, legal. What can Bob do? Anybody got any ideas? What's your first thought? If Bob had all the time in the world, what should he do? Yeah.
So
He should divorce his wife.
Or it could be proven, then it's just, I don't know what you do to prove it.
All right, well, we'll get to that. So Carl today gave the right answer. He should divorce his wife, but she's gone to California and he's got 3 days to close on this sale. So you can't get a divorce in 3 days, even in Texas, which is one of the quickest places to get a divorce. Let's talk about what are the wife's options. If you were the wife in this scenario and Bob called you up, what are some possible things she might say?
She wants half.
Yeah.
Half of the proceeds.
You can sit check or wire.
Yeah. Yep, that's pretty much what one of her options is. So what Bob should do, really legally, from a lawyer's perspective, is either, if he can't get the divorce that fast, he could do a partition and exchange agreement with his wife for that property, where she will sign off and agree that it's his separate property and give him power of attorney to sign her name for the title company to get her off the property. And that would be an enforceable agreement that when they do get divorced, he would get all the money to the property. But in this case, the title company is probably going to issue the check to both of their names. So he's going to have to enforce that partition and settlement agreement in his divorce. Yeah, so Chandra was right. That wife could hold out for money and blackmail him if he wants to sell this property. All right, next. This is we'll go to Josh's question. How do you prove that it was his separate property? So when we get to the divorce, he can prove that all this money belongs to him by proving that it was his separate property. And it's called tracing. So what he would have to do is go back to his grandma's will or her probate estate and show that he inherited that property. And inheritance is then designated by statute, which has less priority than that Constitution that gave us the community property rule. But the statute will say that inherited property is his separate property. So if he can prove it, then he's golden, unless he has commingled either the property or the money that he got from it with community property, in which case it loses its characterization as separate property. So how do you avoid commingling? You keep separate bank accounts. You open a bank account in the name of, so if this title company made the check out to both people, what he should do is take that money and put it in his lawyer's trust account to hold until the divorce is final. Then it is not commingled with his community property. If he puts it in his bank account as a check made out to both of them, then it's commingled. So that's kind of what he needs to do. So we lawyers are special people. We can help in these special situations. But if Bob had gotten that divorce as soon as his wife ran off to California, which he frankly could have done in that amount of time, then he would still be golden. So lesson number 1 from Bob's story: don't commingle, and if your spouse runs off, just go ahead and get that divorce. Y'all can get married again later if you reconcile. Just saying. I know lawyers are such fun people. All right. Scenario number 2. This one is entitled Holy Stepchildren. This is where doing things right and doing things wrong at the same time really, really confounds things. So this story is about Lisa. So Lisa's single mom raised her in a house that the single mom bought and owned. It's her separate property, right? That's pretty clear. When Lisa's a teenager, which was 20 years ago, mom married Stan. So Stan is stepdad, and Stan moves into the house and helps raise Lisa. Stan's name was never put on the deed or the mortgage. So has mom commingled the separate property by allowing Stan to live there? Anybody? Any thoughts?
If he pays a mortgage payment, yes, but if he doesn't.
No, she has not commingled that. She's kept it separate. Even if he contributes money to the mortgage, as long as he doesn't put his name on the mortgage and assume legal responsibility for it, she hasn't commingled it.
Really? Even if he...
I mean, he can come back and ask for reimbursement of the mortgage payments that he put in. Yes, absolutely. But it doesn't change the characterization of the property. So far, mom's doing everything right. Now, Stan, backstory, has 2 grown children, and they were never in Lisa's picture because they were already grown when Stan married Lisa's mom. But Stan's getting older, and he starts to show signs of dementia. So mom becomes his caregiver, and mom redoes her will. She's still going to leave her house to Lisa, but she reserves a life interest for Stan, so he will never be homeless in case something happens to her. So very kind, very nice of mom. So far, she's still doing okay, but then mom becomes ill, and she's starting to have trouble taking care of Stan. So she puts him in assisted living. And now that Stan's living in assisted living, he's not living in the house, but he still has a life estate under her will. Soon thereafter, mom dies somewhat unexpectedly. She was a little bit, sick, but she wasn't expected to die. Stan's dementia is full on. He is no longer capable of making legal decisions and signing legal documents. He can't sign over his life estate interest. As long as he's alive and in that nursing home, as long as he's taking a breath, Lisa can't sell that house. And she needs to sell it to pay some bills. Lisa is even in fact paying stepdad Stan's bills, but she can't sell that house because Stan can't sign away his life interest. Stan never gave power of attorney to any of his children, and his children refused to step in and take legal guardianship of him, which if they did, they could sign away his life interest in the house. Even though Lisa has told them, once he dies, you're not going to get this house. You can't be holding me hostage for money here. They're just like, no, we just really don't want anything to do with our dad, and we just don't want to help. So there. So poor Lisa is kind of under the 8 ball there. So mom had a will, but here's the lesson from this story. Life changes. Don't leave that will in the file cabinet. Review it every few years or when a significant event happens, such as a death, a birth, a marriage, a divorce, or a mental or psychiatric event, incapacity of somebody who you've named in your document. If mom had changed her will to take out that life estate, Lisa could have sold the house. Now that house is sitting there empty, unable to be sold, waiting for, unfortunately, for Stan to take his last breath, which is a very sad situation. And Lisa doesn't even want that to happen to Stan. She doesn't want the worst for him, but she can't help Stan, and his kids won't help him. She can't help him because she doesn't have legal standing to get guardianship of him. She's not his child. He never adopted her. So she can't get guardianship of him. So she's still under the 8 ball. All right, and these stories are all based on true stories. Like I said, Dustin didn't hear my comment about Bob, but yeah, these are stories of real people whose names have been changed. And I'm not even guaranteeing that I can fully help these people, but all I can do is try to warn everybody of the dangers of these potential legal pitfalls. All right, scenario 3, my final scenario of the day. This is the story of Steve. Steve is a successful businessman. He's retired from the oil game and begun a career as a writer at age 60. Steve is one of seven children, and his father was one of 10 children. Grandma and granddad owned a 5-acre farm and has 2 separate houses on it. Grandma and granddad both passed away 20 years ago, leaving 10 children and many grandchildren. Currently, there are 39 grandchildren. Various family members have taken turns living in the farmhouses over the years. No deeds, no rental agreements have been signed. Oh, and by the way, no wills have ever been executed or probated. So now we're 20 years down the road, and 2 of Steve's siblings are living in the residences on the farm. Steve, who is the most successful of his siblings, has been paying the property taxes on the farm because he's happy that his brothers have homes and they're not living with him. So he's paying the property taxes, and he's assuming that he's now the owner of the property because he's paying the property taxes. But now we've got multi-generations here. Grandma and granddad are the last deeded owners of the property. Several of their children have passed away. Some of their children are still living. There are grandchildren living. Grandchildren passed away. But there are right now 43 living heirs of grandma and granddad of different generations. None of the deceased nor their children ever left wills. So now the people who are alive can leave wills, but the question becomes, and Steve can keep paying the property taxes, but the question is now, who owns the family farm? Who has the rights to sell the property? Who has the rights to apply for homestead exemption against the property taxes? Steve's been paying property taxes for almost 20 years and he's never had a homestead exemption on it because it's not his homestead. Who has the right to divide the property? There's 2 houses on it. Who has the right to get a survey done and replat it so both of those houses can become separate properties and separately taxed and separately homesteaded? Who can farm the property and receive income from the farming on the property? Who can build additional homes on the property? In fact, who could even negotiate with developers who might want to purchase and develop the property, which is in a very, very popular section of Fort Bend County. All right, so Bob, Lisa, and Steve all have legal issues that were caused by no fault of their own, and they're having a hard time getting out of them. And in hindsight, there are steps that could have been taken to prevent these legal problems. Knowing enough about the law and when a conversation with an attorney is warranted could save some stress and some expense down the road. It's like that old car commercial, pay me now or pay me later. If Lisa's mom had taken that life estate out of her will, Lisa would be okay. If old Bob had just gotten that divorce when his wife left him, he could have sold his grandmother's home without any consequence, without any problems. But fixing these problems on the other end can be done. It's expensive and lengthy. In fact, Steve's scenario is in year 5 of trying to get everybody put on their potential heirship places in the county property records so that someone can ultimately be owner of that property. So consultation and planning by comparison are not so expensive and well worth the investment. So my purpose in bringing you all these stories is to just give you, and especially people who own real estate and people who sell real estate, like realtors, even mortgage bankers, just to give you some heads up, some red flags. As soon as you see an issue like this come up in a situation where you're trying to buy or sell a house, then please don't hesitate to consult with an attorney as soon as possible to make sure that you are not all the way behind the 8 ball. And now
I have a Steve situation about, I think I've mentioned it before to you, that it's like 100-something acres. You know, grandparents bought it in the 20s, and the same thing. I mean, it's just been, I don't think any of their children are living. There's one of their daughter-in-laws that was still living as of 2 years ago. And now there's 45 grand, great grand, and all that. So say if I do, I'm up against the mountain here, but if I get in touch with all those 40 people, everybody agrees to sell. And with my thoughts is, okay, just have like 5 people with powers of attorney for, you know, maybe 8 other heirs or something like that. Just because I'm not going to have 40 people signing a contract. You know, that's just logistically a nightmare. So say if Judy is one of the heirs and Cindy has her power of attorney to sign for her. So what if Judy dies and now Judy has 2 kids that are going to be, I mean, how does that happen whenever you're under a contract? And what if Judy's kids decide, well, we don't want to sell, mom wanted to sell, but we didn't. It's under contract when she passed.
Well, all right, so I'm going to go back to the question of who owns the property. Has there been an adjudicated heirship?
That's probably a good chance to say no. There has not fully. I'm sure there has been some wills, stuff like that. I would say, and I'm just guessing, maybe 75% not.
All right, so this is the first question you need to find out, because all the powers of attorney in the world aren't going to get you closed if you don't have complete heirship of the property. If there are missing links in the heirship of the property, so you need to get that checked out. And then, are these kids adults or minors? These kids that now don't want to sell or might not want to sell, are they adults or minors? That matters too. If they're minors, you've got to go through a whole guardianship thing for the minors.
Mm-hmm.
Not you, but somebody has to get guardianship for the minors, or get a court order to sell the real estate for the benefit of the minors. But that's about like going through an entire probate. So there's a lot of missing links with ownership of property. That's why I subtitled this little talk, Property Ownership, American Dream or Texas Nightmare.
And I've seen it both ways. I've had them too, where it's an heirship nightmare. Yeah. I'm like, if you just would have had a will, it's sort of all gone away. So
well, if everybody all the way down had a will, that's fine. But even in my case of Steve,
yeah,
if somebody down here in the heirship line had a will, that's great. But when grandma and granddad didn't have the will, all 10 of their kids would have inherited, but then some of them died, and then some of their kids, and then some of the, I mean, and it's, it gets very crazy when it goes back that far. And sometimes that land ends up just being abandoned and going to the state, and that's very sad.
Yeah.
Yeah, any other questions? All right, well, thank you all for listening. I'm going to stop recording, and then I'm going to turn the meeting back over to President Dustin.
You were doing a great job. I'm going to let you finish it out.
No, we're done with everything except for